Hello, good morning. My name is Beth Gibson. I'm the Business Development Specialist for Reeves Group Solutions. Thanks so much for coming today. For nearly 20 years, our company has worked with small to mid-sized businesses to help design, develop, implement, and manage group benefit and savings programs. One of the most rewarding parts of my jobs is being able to work with business owners and managers such as yourself. I believe education is a key to success, and I'm delighted to see so many people here today taking time out of your busy schedule, because I know we all have very busy schedules, to learn more about how to protect your most precious resource, your employees. Today we have gathered experts from a variety of fields who will provide their own unique insights into the challenges facing today's business owners. Our speakers are Jane Gooding, partner, Fillion Wakely Thorpe Angeletti LLP. Jane will be speaking about strategies for dealing with difficult employees, as well as the importance of employee contracts. So without further ado, it's my pleasure to introduce Jane Gooding. Please join me in welcoming Jane.
Okay, so my presentation is going to be broken down into 4 main topic areas. So I want to talk about hiring and some of the hiring processes that we can employ to weed out some of those bad apples. We know that employees are such a vital part of all of our business, so we want to make sure that we have strategies and procedures in place that we can get the best employees when we're hiring. If we hire somebody that turns out to be a difficult employee, that we can manage them properly in the workplace to the best of our advantage. That'll include the use of an employment contract, which is also part of the hiring piece. And then if we've tried to manage these employees and it's simply something that we can't manage and we need to terminate, what are our options and what are our obligations? So just some general comments about hiring and some processes that you can put in play that will hopefully get you along the right track to hiring the right people. You want to make sure that when you're hiring, you don't want to rush into hiring any decisions. You want to take your time. This is where you want to make sure that you have the right people. Think about the kind of person that you want to hire, who's going to be a big, good fit. Ask your employees, canvass who's successful in your organization, what traits have they had, and have that in mind going into the interview so you know exactly what you're looking for. Now, you want to make sure that your practices are objective and free of any bias or apprehension of bias. Now, when I just want to caveat some of these tips. When I'm giving you these tips, I'm thinking that as a third party, if you're going before a court or an arbitrator or an adjudicator, what is that individual going to be looking for? Is the process fair? Is the process unbiased? You have to think, if I'm hiring somebody and this becomes challenged, am I comfortable with this documentation? Am I comfortable with this procedure? Is it clear? Is it fair? Is it objective? So you want to make sure you have an objective basis to your hiring. You want to be consistent in your measurements and scoring. So you want to have some sort of scoring sheet that you use and you apply that to each applicant. Employers now are using more pre-interview questions, and this often helps weed out some of the individuals that maybe just do mass resume submissions that aren't really interested in this position or your organization, or really don't have the skills necessary to do the job. 1 or 2 written pre-interview questions that you can send out to your applicants. Some won't respond, so you know that they're really truly not interested. Others will respond, and you'll get a gauge as to whether or not you want to go to the next step. You want to write your questions in advance, and you want to keep to those questions. You really don't want to sway into other areas outside of the questions you've planned. This is where employers often get into trouble, and we'll talk about some of the trouble under the Human Rights Code or other such areas. You want to make sure that the questions really speak to the essential duties of the job, what you expect the employee to be doing when they're at work, what they need to do the job, the characteristics they need to do the job. Peripheral issues is, again, where employers often run into trouble. You want to avoid questions related to code grounds. You can't ask somebody how old they are. You can't ask if they're married. You can't ask if they have a disability. Have you filed a workplace safety claim somewhere else? You want to avoid questions that can relate or lead to a claim under the Human Rights Code. You also want to make sure you complete an appraisal form. So you want to make sure that you evaluate each applicant after each interview. You have those discussions. You evaluate and then you discuss with your panel. You want to make sure that there's more than one or two people doing interviews. I had a case recently where there's been a discrepancy about the statement that was said in the interview. I think the statement, according to my client, was, "I like working on the weekend when my bosses aren't around." The bosses were conducting the interview. Obviously, that wasn't the best thing to say. The person didn't get the job and they're challenging it. They're saying that something was different was said, but I have a panel of interviewers that say, no, that's what was said, and they've all recorded in their notes. You want to check references. Don't leave the reference checking to the end. When I say the end after you've made the offer, you want to make sure you check the references, and if you don't get a response for somebody, keep trying. Sometimes if the person doesn't call you back, that's a sign. You want to look at the value of the references. Is this somebody's coworker? Is it their supervisor? Is it somebody that can actually truly speak to their abilities in the job? Or is it a friend that's really supporting their reference? If you get a vague reference that says this person was employed from this date to this date in this position and nothing more, that's a big sign that something has happened there and you shouldn't probably be hiring this individual. Now, I looked into, as interviewing and weeding out bad or difficult or employees that may become difficult employees is a whole science unto itself. So what are some things that you should look for in the interview is the person blaming others for mistakes at their past performance? Are they saying this happened and, the team wasn't organized, or, I had a bad manager or a bad leader? You don't want to have somebody that's blaming others because that behavior will likely continue into your workplace. You also don't want somebody to describe something in all or nothing terms. Well, I told them that this should have happened. It should have happened this way, and I was right. You want somebody that's flexible, is going to work with a team, has suggestions, has some self-awareness. You also want to see if people are talking about a problem. Well, what is the problem that existed in your last workplace? You want to make sure that they talk about how it was resolved, and you want to see that they played a role in that resolution as well. Those are dynamic employees that actually will be of value to you in your workplace. Now, this is sort of off topic in terms of, I'm not suggesting that anybody that's protected by the Human Rights Code is a difficult employee, but what happens is if there's a Human Rights Code issue that arises during the interview process, these situations can become difficult. So the Human Rights Code, as you know, is a statute in Ontario that applies to all Ontario workplaces. And it's a piece of legislation that prohibits harassment and discrimination on certain enumerated grounds. There used to be 13, it's now been extended. These grounds include race, sexual orientation, disability, sex, which includes pregnancy, ethnic origin, citizenship, religion, record of offenses, which has a specific definition if they've not been pardoned. If they've been pardoned, then you can't discriminate, family status and marital status. There's also some transgender protections as well now. What I'm seeing happening is that the Human Rights Code provides protections in employment. Employment is broadly defined, so even when you're interviewing somebody, even though they're not your employee, they're going to fall under this employment protection. Hiring practices fall within the gamuts of the code protections. So you need to be very careful when you're hiring that you're not asking questions that are going to get you into hot water, where somebody who doesn't get the job thinks they didn't get it because they had a disability or because they were a female, et cetera, et cetera. You also need to be careful, and it's very surprising, but these issues are coming up where people in their job postings are being accused of breaching the code for things like new graduate as a qualification. Well, you think, why would that be an issue? Well, that's been challenged on the basis of discrimination on the basis of age. You're looking for a younger employee, not an older employee. So you have to be very careful because there could be adverse discrimination coming out of your hiring practices. This is why the pre-planning, the objective questions, measurements, and scoring is so important at the outset, not as in terms of weeding out difficult employees, but also involving and avoiding some difficult situations. It's also important to remember that the Human Rights Tribunal that administers the Human Rights Code has broad remedial powers. And in some cases, they may move to award the individual who didn't get the position. So you need to be very careful as to the outcome of your hiring process. When you decide, you've gone through the interview process, you think you've got a great candidate, now you need to think about offering them the position. And I can't emphasize the importance of an employment contract at this point. I have so many clients who call me, and usually when they want to terminate somebody and say, how much is it going to cost me to terminate this person? And they're astonished by the cost of terminating an employee these days. And the first thing I will always ask them is, do you have an employment contract that limits what we have to pay them when we fire them? And if the answer is no, things get very tough from a financial perspective and potentially a litigation perspective. Employment contracts, just generally, they allow you to specify the terms. Everybody understands the same, everybody understands what the terms of the employment is going to be, how much you're going to get paid, how much vacation you have, your bonuses, your commissions, whatever is in there, it's all covered off, it's all addressed. There's be no issues. Any disputes regarding the employee's entitlement, you can refer to that employment contract. You can refer to any policies, and you can incorporate your policies into the employment contract. The employment contract can also allow you to have some flexibility in that if you say something, for example, that the employee will be assigned to this location, but you reserve the right to change them to another location as you see fit or in accordance with your business operations. Having that kind of clause in there will allow you to have more flexibility in dealing with the employee and avoiding claims such as constructive dismissal. Now, this is a question that often, or an issue that often arises, is that when you have an employee sign an employment contract, you have to have them sign it before they start working. If I am a plaintiff lawyer, so if I am the lawyer of an employee who's been terminated and they show up with an employment contract that limits what they get on termination, I'm going to do everything I can to have that contract voided. And if I find out that they started work on May 1st and the contract is dated May 3rd, I'm going to say that the contract is void, and any provisions in there that I don't like are therefore unenforceable. So you cannot have an employee start work and then sign the contract. You need to make sure that they have the contract well in advance. If they have it a week in advance and they have an opportunity to take it to legal counsel, even better. If you have employees that have already started work and you want to get them on an employment contract, this is difficult unless you provide them something in exchange for signing that contract. A contract has 3 elements. You have to make the offer, there has to be some consideration for that offer, and there has to be an acceptance. So in a normal employment circumstance, you'll make the offer, so we're going to offer you job A, and we're going to, as consideration for you accepting that, we're going to pay you this and give you these benefits and do all those things. This is the consideration. They accept that. If they're already working, you don't have the consideration. You're not giving them anything because they've already got it. They've already started, so the contract falls apart. So if they're already in your workplace and you want to employ employment contracts, you have to have that consideration piece. So what are they going to get for signing this? And this is why you hear about signing bonuses. This is where you hear that people sign new contracts when they get a promotion or a wage increase, because they're getting something in exchange for agreeing to the terms. And you have to be careful. You can't give somebody, a 20-year employee, $50 for signing a contract that's going to limit substantially their obligations on termination. The consideration has to be in keeping with the benefits that they're giving up. You want to make sure that your employment contracts are kept up to date. So if you do make amendments, you want to make sure that those amendments are attached in writing. And you want to keep the language simple. Unfortunately, as employers, and a lot of employers have learned this the hard way, if a clause in your agreement isn't clear, it will be interpreted in the employee's favor. So if you say this clause means this as the employer, and the employee says, no, I thought it meant this, the courts will, in most cases, unless the provision is truly clear, side in favor of the employee. So you want to make sure your language is simple so the employee understands what they're getting into, and clear so that there's no disputes on the language. I think it's also important to say that even if you don't have a written employment contract, everybody who is your employee has an employment contract. It may just be an oral contract. The oral contracts are what causes the problem, and that's why the written contract are so important. And I'll get into why the oral contracts are problematic when I speak to the provisions in the contract. So the two key provisions you want to have in your employment contract are a probationary clause and a termination clause. And it's hard to talk about termination when you're excited, you're expanding, you're hiring these great employees. You really don't want to talk about what it's going to be like when they're terminated. But you never know what's going to happen. There could be a downturn in the economy. They could be an awful employee. There's a ton of different reasons as to why the employment relationship may end. You have to deal with it at the outset. And the probationary clause is important because that gives you a quick and relatively inexpensive way to get rid of an employee who really isn't a good fit. So they got through the interview process, you thought they would be great, they get into your organization and it just isn't working out. Now, employers assume that everybody who starts is on probation. It's not true. You actually have to have in the offer letter or the employment contract a clause saying that the employee is on probation. Don't assume it because the courts won't if there's ever litigation. The probationary clause that you want to include in your contract is that when the employee is terminated within the first 3 months of their employment, they will not be entitled to any notice of termination under statute, which is the Employment Standards Act, or any notice at common law. So when we know that when an individual is terminated, we have certain obligations as employers. Those obligations are to meet whatever notice and severance, if applicable, obligations under the Employment Standards Act. Those are required by law. We can't contract out of the Employment Standards Act. That's it. We have to pay it. If we don't have a written employment contract that limits what happens on termination and we have an oral contract, what happens is the judge-made law or the common law comes in and inserts an implied term into every oral contract that says you're entitled to reasonable notice at the time of your termination. Reasonable notice used to be 1 month per year of service. So if you have a 6-year employee, it used to be that you would be required to pay them 6 months' wages at termination if you have only an oral contract. That has been expanding and growing. So these are huge amounts that we're looking at. In the case that I was talking about, the employee was a tax accountant. She had worked 1 month for the employer. The employer didn't have a probationary clause in the employment contract. The employee was terminated and provided with no termination pay. Because they'd only been employed for 1 month, under the Employment Standards Act, anybody that's employed less than 3 months is not entitled to any notice. So they looked at the act and said, okay, this is what our requirements is. We don't have to pay her anything. She didn't have a written employment contract, didn't have anything that addressed the probationary period. She filed a wrongful dismissal complaint against the employer saying you didn't give me enough notice or warning of my termination. I'm entitled to reasonable notice at the common law. I'm entitled to this judge-made common law notice. And the courts agreed, and they gave her 4 months. A 1-month employee, and this employer had to pay them 4 months' wages as notice. So these are big issues that can be easily corrected with an employment contract. I also get questions from employers, well, how long does my probationary period can be? Can it be 6 months? Can it be 8 months? Well, you can define that in contract, but you need to be careful. Again, the Employment Standards Act, anybody that's employed for longer than 3 months, whether you call them probationary or not, is entitled to certain payments under that statute. So you may term them internally a probationary employee, but you have to be cognizant once it's 3 months of continuous employment, you owe them some money if you're going to terminate. Now, probationary employees are generally easier to terminate because you don't have to establish just cause. If you establish a probationary period, the courts have accepted that there's a lower threshold during that period of time. So you don't have to establish just cause, which I'll get into a little bit later, but you can establish really that this employee was not suitable. But what the courts have recently said, and again, this was a small claims court decision, small claims court recently increased their jurisdiction to handle claims up to $25,000, so they're actually getting a lot more of the employment claims than they ever got before, so they're going to be determining some of the employment law going forward. They said you need to warn probationary employees. You need to act in good faith and you need to behave reasonably. In this case, with the tax consultant, the employer didn't warn the employee that her employment was in jeopardy. She had no idea this was coming. According to the court, she was effectively blindsided, which the court took issue with, which may have played into the substantial award, the 4 months as the outcome. The most important clause in employment contract is the termination clause. So you need to make sure that in your contract you have a clause that deals with the employee's entitlement on termination. So again, if you don't have that clause, you have to pay the minimum standards under the Employment Standards Act, which is 1 week per year of service for notice, up to a maximum of 8 weeks. So a 7-year employee would get 8 weeks notice of the termination or 8 weeks pay in lieu of that notice. You also have to pay severance if you have a payroll of more than $2.5 million and the employee has been employed for 5 years. If you don't have a payroll of more than $2.5 million and you're not laying off 50 employees at a time, you don't owe the severance. But if you don't have an employment contract, you're going to owe common law reasonable notice, which again could be anywhere from 3 to 6 weeks per year of service, so it could be a huge obligation for your long-term employees, and even now, as we've seen coming out of the small claims court, a big payout for short-term employees. If you have an employment contract, you can agree to limit what the employee is entitled to at termination, and you can fix that by agreement, so it could be 3 weeks per year of service. You have to be careful that you don't have a contract provision that provides less than the Employment Standards Act, or it will be void. You see that a lot of employers run into problems because they say, we'll give you 2 weeks per year of service. That will work in some cases, but won't work in others. For example, if you have an employee that's worked for you for 10.5 years, or let's say, let's make it simpler, 5.5 years, for example, they would get 5 weeks notice or pay in lieu thereof, and 5.5 weeks severance. So you have to make sure that your 2 weeks times their years, 10 weeks, is greater than the Employment Standards Act, which is 10.5 weeks. So you, by not paying that extra 3 days, are going to avoid that provision, and then it would default to common law reasonable notice. Do you have a question? Does that make sense? Okay. So we want to talk quickly about managing difficult employees, and I know I'm running out of time. As I said, this is such a huge topic. My advice to my clients is always, if you have an issue, meet with the employee right away. I'm always getting calls that says, this person's been a problem for years, they're really getting on my nerves, I want to terminate them, I don't have an employment contract, they've been with me for 8 years, and then I say, okay, well, you have to pay them 9 months wages, or you know what, this person's 64, so you might owe them 10 months wages, and then, there's silence on the other end of the phone. So you need to make sure that you manage these employees, which may give you the option of terminating for cause later on, or at least may give you some negotiation power moving forward in dealing with these employees. So you want to meet with them when there's an issue. You want to say clearly, this is our expectation of you in this position. We expect you to arrive at 9 o'clock. On these 3 occasions, you've arrived at 9:20. This is unacceptable. So you want to say, our expectations, you arrive at 9. You haven't met our expectations on these 3 occasions. We're not happy with that, and we expect you to improve. You give them a timeline for improvement. We're going to meet in a month, and we're going to reevaluate. How are you late again? Have you been late in this 1 month period? You want to confirm your discussion in writing, and you also want to confirm any of offers of help. Is there anything that we can do to help you get to work on time? What is the issues? Get it all out on the table now. Don't be afraid to ask the questions at the front end, because inevitably they will come up in a horrible way in litigation. You want to warn the employee, if you don't come to work on time, you could be fired. We may discipline you or we may fire you. Be upfront about it so they know. They've been warned. And these are the things that arbitrators and adjudicators and the courts will look for. So you want to confirm in writing that you've done all this. Expectations, where they failed to meet expectations, offer of help, consequences. If there is a problem with the employee, the first, you want to go through the progressive discipline. This is more in a union context, but you can also do it in a non-union. You want to do a coaching letter first, say this is what our expectations are. If they continue, you want to give them a formal written warning, and then you might want to move to a suspension or a termination. Of course, if they punch somebody in the front lobby, then you might want to go right to the termination. But if it's things with related to job performance, less egregious misconduct, maybe sloppiness or laziness, then you might have some more room to work through this progressive discipline. And inevitably, we'll all have employees that we need to terminate. Hopefully, we have an employment contract in place. If not, we'll need to determine, do we have cause? Cause means not a reason, but a reason at law. A reason justified that we don't have to pay this individual common law reasonable notice. If we don't have cause and it is a high threshold, we have to pay either what we've set out in the employment contract. We always have to make sure we meet the minimum requirements under the Employment Standards Act, which may be incorporated into the contract. If no contract, reasonable notice. There's no near cause, so I get a lot of calls saying, well, they're really bad and they did this and they did that. You either have cause or you don't. And this is why you need to manage these issues as you go along, because the courts are not going to be sympathetic. If you have a terrible employee who's not doing their job, but it's still not cause, they'll still get the 10 months. The same as an employee that simply got laid off because of a downsizing or a loss of a major client, they get 10 months. The court doesn't distinguish. You have the onus of establishing cause if you allege it. It's going to be very fact-specific to a particular case. It has to be something real and substantial. And just one quick comment for those people that really know the Employment Standards Act really well. The Employment Standards Act, again, as I said, sets out the minimum obligations for notice and severance. If you terminate an employee for cause, it doesn't necessarily mean you don't have to pay those minimum requirements. In order to get out of paying the minimum requirements, you actually have to show willful disobedience, neglect of duties, or what's the third one? Dishonesty, I think. I'll have to double check. But you have to show that there's a higher level even than cause to prevent payment under the Employment Standards Act. So you need to be cognizant of that. Even though you may say you have cause, you may be still taken to the Employment Standards Board to establish this higher threshold. These are some examples of things that have been found for cause. Just because someone stole something doesn't mean you'll have cause in all circumstances, but these are some of the examples where cause has been found. So you have theft, egregious acts of dishonesty, insubordination, sexual harassment, misrepresentations at the time of hiring. Say I have a diploma or I have this certificate and they don't. You might have cause in those circumstances to terminate if that's required to do the job. The majority of the terminations are, however, without cause because cause is so difficult to prove. And a lot of employers don't want to engage in litigation around whether or not they have cause. So they do a not for cause, and then they decide how much they're going to pay the employee. And again, this is dependent on the employment contract and the Employment Standards Act and reasonable notice. If you pay more, then you're obligated under the Employment Standards Act. So say I'm a 5-year employee, and under the Employment Standards Act, I'm only entitled to 5 weeks. I'm not entitled to any severance because my employer doesn't have a payroll of more than $2.5 million, but I'm offered by my employer 3 months. For example, as a reasonable notice period. You as the employer, because you're offering more than what's legally required, you can obtain a full and final release, which means that they can't bring litigation against you. Be careful. Home Depot just got slammed yesterday because they forced the employee, a 20-year employee, to sign a release at the termination meeting without having time to consider the package. And the package offered slightly more than the Employment Standards Act, so technically they could request a release, but the court felt that that was completely egregious and took advantage of the employee in a very emotional state, and they awarded him a substantial notice period. They avoided the release essentially and allowed him to proceed with litigation. There's also some difficult terminations. I just wanted to flag them because this is a whole other presentation onto themselves. But if you've got somebody on maternity leave, for example, and you want to terminate them, think about that. There's obligations under the Employment Standards Act that says you have to reinstate somebody coming off of a maternity leave to comparable employment, unless you're terminating them for business or operational needs. So I had a client that had to lay off a ton of people the other day. Some were on maternity leave. We could prove that this was really a business operational decision. We were downsizing. If you're just laying off this individual and they're on maternity leave and there's no, and there may be a comparable job we can put them in, we need to be careful because we might run afoul of the Human Rights Code and the Employment Standards Act. Also, with a disability, you need to be careful because you have the duty to accommodate under the Human Rights Code, and that duty lasts to the point of undue hardship, which is, quite an onerous obligation on employers. On WSIB benefits, you can't terminate somebody at 6 months of an injury, a workplace injury, as the WSIB will make a presumption that you're terminating them because they were injured. You'll immediately sort of it's a guilty until proven innocent kind of presumption coming from the board. So you'll want to be careful because you have reemployment obligations that last for up to 2 years in some circumstances. And you may have everything right. You may get everything right. You may have a claim that says you've harassed somebody, you've discriminated against them, you know that it's not true, and you've proved that it's not true, and then you end up terminating them or do something against them for bringing the complaint. You can't take any actions of reprisal against an employee for filing a complaint against you, for alleging a safety issue under the Workplace Safety and Insurance Act. So if you're going to discipline an employee who has brought a claim against you as an employer, you might want to run it by somebody to see if that's going to be considered a reprisal and get you in even more hot water. And then just with finally the terminations, you want to make sure you talk about what you're going to do. Is it cause? Is it not for cause? What are you going to say in the interview? Do you need any legal advice? How much is this going to cost you? Should you obtain a release? How long should you give to review the release? All of those things need to be thought out in advance. Then you want to draft the termination letter. We're going to give you this amount. We're going to give you these benefits. We're going to give you, career counseling. We'll give you $200 to take this to a lawyer of your choosing to look at. All of those things you want to decide what you want to offer this particular employee and have that all in writing. Then you want to meet with the employee. You don't want to engage in debates with the employee. It should be a short and sweet meeting. Very clear. The purpose of this meeting is to terminate your employment. You want to review the letters. Then if you want to hand it over to somebody else, a career counselor, or a transition, HR transition manager, something like that, who can help them and talk to them. Then you want to make sure they understand they don't have to return to work and that they are free to leave at that point. Then you want to make any internal announcements. You don't want to give too much information off in those emails, just so-and-so is left to pursue future endeavors. We wish them best of luck in their future. And then make any administrative changes. You have 5 days to issue the ROE. You want to talk to your benefit providers. Just a quick note on benefits. You have to maintain all terms and incidents of employment during the notice period under the Employment Standards Act. So if the person is entitled to 6 weeks notice, or you've given them 6 weeks pay under the Employment Standards Act, you still have to keep their benefits in effect for 6 weeks. Some employers want to keep the benefits in play for longer periods. So if you've given that employee 6 months reasonable notice, you might want to keep the benefits in play during that time. That's going to depend on your individual plan. So you'll have to talk to your benefit plan provider. But there was a recent case where the employer terminated LTD benefits during the reasonable notice period. An employee unfortunately got very sick with cancer, sued for the LTD benefits and won.